Good evening. On behalf of the New York City Bar Association's Environmental Law Committee, I welcome you to tonight's event about New York's proposed Environmental Rights Amendment, also known as the Green Amendment. I am Margaret Berry, one of the co-chairs of the Environmental Law Committee at the City Bar, along with Bethany Davis-Knoll. We would like to thank the Energy Committee and the Government Ethics and State Affairs Committee for co-sponsoring tonight's panel. And we'd also like to thank Martha Harris and others at the City Bar for making it possible for us to host this event. If you are a New York State voter, your general election ballot includes, as Proposal 2, a proposed amendment to the New York Constitution that would establish the right of each person to clean air and water and a healthful environment. Our speakers tonight will shed more light on how this environmental rights amendment arrived on our ballots and what its implications are for environmental protection in New York. Our program will begin with an overview of the amendment, which we'll follow with a panel discussion of the amendment's potential impacts on advocacy and litigation, among other topics. In the last 10 minutes or so, we will have time for questions, so please submit them throughout the presentation using Zoom's Q&A feature. Our introductory speaker tonight is Katie Q, the Haub Distinguished Professor of Environmental Law at Pace University's Elisabeth Haub School of Law. Professor Q's scholarship focuses on climate change and sustainability, and she has authored and edited numerous publications on these topics. In 2017, she served as the chair of the New York State Bar Association Task Force on the Environmental Aspects of the New York State Constitution, which produced a report and recommendations that same year. Earlier this year, Katie spoke to the City Bar's Environmental Law Committee about the Environmental Rights Amendment, and we are grateful that tonight she is here to guide this broader audience through some key issues about environmental rights and the proposed amendment. Katie, I will turn things over to you.
Thank you so much, Margaret, and thank you to the City Bar for hosting us and for everyone who's here attending. We're excited to see this on the ballot. I'm going to share my screen because I have a PowerPoint to provide some information about the Green Amendment. So to provide a little bit of background for you, I provided the proposed text of the amendment to the New York State Constitution. I first became involved in this issue back in 2017. So there are two routes through which New Yorkers can amend their constitution. One is to vote to hold a constitutional convention, and the other is for two successive sessions of the legislature to adopt the text of an amendment that is then adopted by voters. In 2017, I was part of a task force formed by the Environmental and Energy Law section of the New York State Bar Association. We were asked to evaluate New York's constitution from an environmental perspective. And the task force brought together New York environmental attorneys from across the state. And something that became clear as we started to work together was that many of these attorneys had spent much of their careers enforcing provisions in the New York State Constitution, known as the Forever Wild provision, that protect the Adirondack parks. And these attorneys were adamant that we not do anything that would result in touching a hair on the head of those provisions, because they had found them to be so useful in terms of protection of the Adirondack Park. As our task force did our research, we also read decisions from a number of other states that have environmental rights expressed in their constitution. We became convinced of the potential value of those constitutional rights. So our task force ultimately recommended that New York consider adopting an environmental right in its constitution. Of course, New York voters did not vote to hold a constitutional convention. However, two successive sessions of the legislature did adopt this Green Amendment text, and that's what appears before us as Proposition 2 on the ballot this year. And so that's why we have an opportunity to consider amending the Bill of Rights section of the Constitution to add this right to a healthy environment. So to put this a bit in perspective, environmental rights are not uncommon, particularly internationally. They're a little less common in the United States. It kind of depends how you count it. There are a number of state constitutions that reference the environment in some way. There are probably only 2.5 or 3, depending on how you characterize Hawaii. states who have environmental rights in their constitution that by virtue of their wording, placement, and interpretation by courts have truly proven to have significant impact. In terms of thinking about what the potential value of a green amendment could be, I'll offer to you some of the benefits of a green amendment that are frequently identified. And what I've tried to do is match them up with specific cases from other states that have environmental rights to give a specific example of each. So turning to the first potential value of an environmental right, many argue that constitutional environmental rights can actually function to support implementation of environmental laws, that instead of working against one another, they actually work in synergy. So the environmental right can help with respect to robust implementation of environmental statutes that we have. And what I've given you is a quotation from a case coming out of Hawaii. So Hawaii has a law that requires its Public Utilities Commission to consider the impacts of fossil fuels on greenhouse gas emissions and to try to reduce the state's dependence on fossil fuels. What happened in the Maui case was that the Hawaii Public Utilities Commission had approved a power purchase agreement extending a contract to a partially coal-fired plant without considering greenhouse gas and other air quality impacts. And the Supreme Court of Hawaii, invoking in part their environmental rights in their constitution, found that at minimum, the Sierra Club was entitled to have a hearing to explore some of the issues related to the potential greenhouse gas emissions from the partially coal-fired plant. So in this sense, the environmental right was coupled with the existence of the Hawaii law requiring the consideration of those impacts, and perhaps I think provides a nice example of a way in which an environmental right can work in synergy to improve the enforcement and implementation of environmental laws that we already have on the books. I think another example of the value of environmental rights is to view them as a way to tap the brakes when we're faced with short-term environmental exploitation that can have long-term environmental harms. And the case I think that provides a nice example of this is the Robinson Township case from Pennsylvania, which was a plurality decision. I think only 3 judges actually joined the portion of the opinion that discussed the environmental rights amendment. But what this case involved is, this is a case that struck down several provisions of a state law that was designed to promote the implementation of fracking in Pennsylvania. And in particular, one of the portions that the decision struck down was a provision in the state law that would have overridden local zoning designed to regulate or limit the use of fracking in communities. Another good case that I would cite to as an example of a way in which an environmental right can function to provide a benefit where you end up with legislation that perhaps represents a public choice distortion. So a situation where private interest has succeeded in getting a provision in law that would have potentially significant environmental impacts. And so in this Montana case, there was large mining interests were interested to build a large cyanide leach gold mine on the Blackfoot River, which is actually the location where a river runs through it, was shot. So many of us who haven't been there in person are probably familiar with the scenery. In the usual course, Montana law would require what's called non-degradation review, or in other words, a review of the potential impacts of effluent on a high quality water like the Blackfoot River before allowing it to take place. However, the Montana legislature had adopted a statute that gave a blanket exemption from non-degradation review to certain so-called non-significant activities, including discharges from monitoring well tests. Now, in this particular case, the monitoring well tests that were proposed to be conducted in advance of construction of the gold mine would have resulted in significant arsenic being put into the Blackfoot River. And the Supreme Court of Montana held that to the extent that the statutory exception arbitrarily excluded activities from non-degradation review without regard to the nature or volume of the substances being discharged, it violated the constitutional environmental rights under the Montana State Constitution. I think all of these are some specific examples of cases in which those general values that are oftentimes ascribed to environmental constitutional rights have been given effect. Another common value that is ascribed to constitutional rights, environmental rights, is the potential that they can help citizens to have a tool to help fill gaps in existing environmental laws. And so one case that is pending right now in the state of Montana, in this case, a group of youth in Montana have sued Montana, challenging a state energy policy that promotes fossil fuels and also exempts from state environmental impact review, greenhouse gas and climate change impacts. So this case, a state trial court declined a motion to dismiss the plaintiff's demand for declaratory judgment. So this is a case that's actually pending. Now, if you're thinking, well, we actually have really strong climate change laws in New York, I would tend to agree with you there. However, I think that doesn't mean that we have no gaps at all in environmental law. So one issue that oftentimes comes up with respect to in discussions around the need for a constitutional environmental right in New York is some express the concern that we already have a significant body of environmental laws in New York that are relatively protective, and we have so a policymaking scheme and expert regulators attempting to implement those laws. And so this is, I've taken this quotation from an explanation of what some of the those who are concerned about the potential impact of an environmental right question whether there are gaps in our environmental laws in New York. And the view that they express is that, well, to the extent that there are ways in which our environmental laws in New York are not being implemented effectively, those aren't really gaps, but those reflect the fact that we can't possibly do everything perfectly. So it's an assessment by regulators about what is in the best overall interest of the public. And I think the difficulty that taking that view presents is that there's clearly one subset of the public that this overall interest of the public tends to favor, and other disadvantaged groups who tend to be consistently over time disfavored with respect to this balancing and these assessments. And so I would cite to as an example of a potential persistent gap in environmental laws generally and in New York specifically, the idea that we have environmental justice communities subjected to disproportionate and cumulative environmental harms. To the extent we're striking a balance in the interests of the general public, that public has historically been defined in a somewhat narrow way that has left some communities out. As another example of something that you might consider a gap in environmental laws, you could think about emerging contaminants that are not yet subject to regulation under the Safe Drinking Water Act, but are nonetheless present in drinking water in significant quantities. And I remember at one point reading a newspaper article in which the Business Council's Director of Government Affairs was commenting that an environmental constitutional right was unneeded. And when asked about residents in Hoosick Falls struggling with contamination of their drinking water supplies, his comment was that they already have multiple means of legal recourse. And of course, to some extent that's true if you count the possibility of maybe potentially bringing a common law toxic tort suit down the line as a means of legal recourse. But I think for many of us, we find the possibility of ex post compensation for exposure to toxic substances not sufficient legal recourse at all. And in fact, those who in Hoosick Falls had to go hand in hand and ask for legislative help to address this issue, which ultimately they did receive. But I think it's interesting to think about if we had, imagine a world where we had a constitutional right to a healthy environment, whether the concerns that had long been raised about PFAS in drinking water might have received prompter and earlier attention. So in terms of thinking about New York's Green Amendment, one question that often comes up is, how does the language that's been proposed for inclusion in New York's Constitution compare to the language in other states? Isn't it very broad? What does it actually mean? And is it really necessary? Don't we already have some provide for environmental protection in New York's Constitution already? So what I wanted to show you to give you a sense of contrast. So this is the Environmental Rights Amendment in Pennsylvania. And you'll note that the first sentence of Pennsylvania's Environmental Rights Amendment is very similar to the language that's been proposed in New York. Pennsylvania then goes on to articulate a public trust responsibility by the Pennsylvania government. And that public trust language in their constitution has been very significant in the implementation and interpretation of the environmental right in Pennsylvania. However, if you look at Montana's constitutional language, it is quite similar to the language that has been proposed and is being considered in New York. And what I'll show you is, this is the language that we have. Let's see. This is the language that's been proposed in New York. And then in addition, I've also concluded language that we already have in our state constitution. So if you're wondering, why do we need, what would the benefit be, and why do we need an additional environmental right, since we already talk about the state shall conserve and protect its natural resources in our constitution, there are two answers to that. So the first is that constitutional language that already exists with respect to the environment in New York State's constitution has been held by courts not to be self-executing, which essentially means the language has been by courts interpreted only to mean and be actionable to the extent that the legislature has made it so through legislation. And something that is very significant about the language that's been proposed to be added to the New York State Constitution is that it would be located in the Bill of Rights provision of the Constitution, which hopefully means that it would be interpreted not only to be self-executing, but to provide a fundamental right. That brings us to questions that arise with respect to how the Green Amendment language, if adopted, would be interpreted and applied by courts. It certainly is very broad language, but it is not dissimilar from other broad environmental rights that other broad constitutional rights that are included in the Bill of Rights. In terms of the type of precedent and guidance that courts in New York would have, they would have a significant amount of case law from other jurisdictions implying their environmental rights, our experience applying environmental laws in New York, and of course our experience, the New York court's experience applying other rights expressed in the Bill of Rights provision. Now, I'm about to offer you some best guesses about how the environmental right in New York would be applied. So probably the single biggest concern that gets raised about the adoption of environmental right is the concern that it might lead to kind of a tsunami of expensive litigation. And in terms of thinking about that, I think it's important to note that other states that have robust environmental rights haven't experienced large volumes of litigation. And in addition, there are some reasons to think that the way in which New York courts are likely to interpret the Green Amendment in New York would limit the volume of litigation as well. So if you look at Pennsylvania's Environmental Rights Amendment, which really new life was breathed into it through the Robinson Township decision, in the period immediately there, the 4-year period immediately thereafter, there were only 13 opinions that produced a holding under the Environmental Rights Amendment. So 13 opinions over 4 years, certainly not kind of a tsunami of litigation, although I would be the first to submit that I would fully anticipate that were we to amend the New York State Constitution to express an environmental right, there would be a period in which there would be litigation aimed at defining the contours of the right, who can bring a right, how, and providing guidance about how courts should apply it. One point to make that would likely limit the volume of litigation is that looking to precedent in New York and how other similar constitutional provisions in the Bill of Rights have been enforced, it seems likely that the Green Amendment would be held not to be enforceable against private parties, which would be one way or one reason why we could probably anticipate that the volume of litigation wouldn't be unduly significant. Another point is that the environmental right would likely be interpreted to apply a limitation on government action and not to authorize a damages remedy. And again, I'm making a prediction here based on New York case law in New York. But New York, this is kind of, I've given you here the factors that courts will look at in New York in deciding whether a constitutional provision implies a damages remedy. And I would flag for you that the decision in Brown has since been applied with significant restraint. Even in Brown itself, the Court of Appeals emphasized the limited nature of its decision, characterizing its holding as recognizing a narrow remedy designed to provide appropriate protection against official misconduct. So I think for all of these reasons, it seems there are, I think, a number of reasons to think that concerns about an explosion of expensive litigation are probably overblown, just based on the experience with environmental rights in other states, based on, I think, some reasons to think that the environmental right would be interpreted not to authorize actions against private parties and not to authorize a damages remedy. Nonetheless, looking to other states, I think there are significant value that could come from having an environmental right in the New York State Constitution. And I think I'm done there. And I think this is right on time, Margaret, if I'm if I'm looking at my watch correctly.
Yes, perfect timing. And thank you for providing that very useful backdrop for the rest of our discussion. Our other panelists who are going to participate in the discussion tonight represent a range of experiences and expertise. Two of them from other states that have environmental rights in some form, codified in some form. And so I'll go ahead and introduce them, and then we'll move on to our discussion. First tonight, we have Kate Kurera, who is the Deputy Director at Environmental Advocates New York. Before she joined Environmental Advocates, Kate worked in a number of roles on federal, state, and international environmental law and policy, including as a solicitor and legislation officer for the Department of Environment, Land, Water, and Planning in Melbourne, Australia. Next, we have Justine Massey, who is a policy manager and attorney at the Community Water Center in California. And I believe that Justine will talk more about the Community Water Center's work during the panel discussion, but some of her work I know has focused on sustainable groundwater management. And finally, Lauren Williams, who is the founder and head counsel of Greenworks Law and Consulting based in Pennsylvania. And Lauren was one of the attorneys who represented plaintiffs in the landmark case that Katie mentioned, Robinson Township v. Commonwealth, in which the Pennsylvania Supreme Court held that certain provisions of a state oil and gas law violated the Environmental Rights Amendment of the Pennsylvania Constitution. And I'm sure we'll probably talk about that case a little bit more during the discussion as well. But first, we're going to stick for the first question with New York and direct this question initially to Kate. And we already heard a little bit from Katie about the process for getting the Environmental Rights Amendment onto the ballot. And I was wondering if you could tell us more about the genesis of the Environmental Rights Amendment and what are the specific perceived needs that are driving it?
Great. Thank you, Margaret. Hi, everyone. So yeah, I think this is what I have to say dovetails nicely into what Katie was saying in terms of the point in time in which the Law Association was looking at the or they were doing the review of the Constitutional Convention. And about in 2015, 2016 is when the community of Hoosick Falls really discovered their water contamination crisis of PFAS chemicals. And that process was unfolding. I wasn't with environmental advocates at the time, but that is a community that our organization has worked quite closely with really from the onset of that contamination crisis surfacing. And, in those early, months and time with that community, moms and community members are sitting around the table really just baffled by the fact that, we take these things for granted, that we should have the right to clean air. And everyone started to look around the table and ask themselves this question, like, why is it so difficult to get to address this issue that we're confronting? I mean, we have illness and sickness and our children are being poisoned. And why is this such a challenge to even bring a suit against it to get a remedy or to get some kind of recourse? So that it was at that point in time that our organization was really working with the grassroots, with the impacted communities to start figuring this out. And I think that really is when a lot of this timing corresponds to when the recommendation had been made about a Green Amendment or Environmental Rights Amendment to the state constitution. And at that point in time, I believe it was 2017, might have been the first bill that was introduced into the state assembly. Now, kind of fast forward, if folks remember, the New York State Senate was Republican driven for 10 plus years. And that bill was introduced, I believe, in 2017 and maybe in 2018 and didn't pass the assembly, but didn't go any further. So fast forward to 2019, at that point, I was actually with EA. It was a real watershed moment to really go after passage of this, for the first passage of this amendment. So we worked very closely with a number of other environmental advocacy groups, really to advocate and lobby the state legislature to pass this bill in 2019, which they did. And, we prepared ourselves for a second passage, which happened this year in 2021. So, in terms of the perceived gaps, I think, obviously Katie addressed a lot of the reasons. I think some of the most compelling reasons that I like to talk about are really the fact that it can complement existing environmental law, and that existing environmental laws and regulations are really focused on these two things of limiting pollution, assuming pollution happens, and limiting it, as well as cleaning it up. And there is some gap in there about really preventing the harm as the first step to in the first step of protecting New Yorkers. And I think that adopting this type of framework and this constitutional right really shifts the paradigm in a little way in terms of thinking about environmental law and regulation from a precautionary principle approach or preventative approach, which, as Katie said, is not so common in the US, but it really is not uncommon or novel. It is novel here, but not in other places in the world. I was going to say unnovel, but I don't think that is really the right way of describing it. And I, as Margaret mentioned, I worked in Australia for 9 years, where we really worked on completely adapting their environmental regulatory framework from a preventative model in the statute book. So it's really been interesting for me to see this kind of come full circle, being back in New York, understanding our kind of history of environmental law and regulation here, and seeing the potential that this kind of precautionary approach, preventative approach being enshrined in the Constitution, really helping to drive decision-making in a different way.
Thanks, Kate. That's really interesting. I don't know if any of the other panelists have something they wanted to say in response to that. I was thinking we could just move to talk a little bit more about a place where an environmental right has been established for a while, and that's in California, which in 2012 enacted a statutory right to human right to water, and which is something that the Community Water Center worked on. And Justine, since that time, how has the Community Water Center used the human right to water for community organizing, policy advocacy, and public education? And are there lessons that New York communities and advocates could take from work that has been done in California under the human right to water?
Yeah, thanks, Margaret. My dog says hi. So I'll start just by giving a really brief introduction of Community Water Center. We're a nonprofit in California, and going on 15 years now, Community Water Center has worked towards realizing the human right to water for all communities in California through education, organizing, and advocacy. So we've been at this work since before it was recognized as a human right in our state. We have our main office located at the heart of the San Joaquin Valley in Visalia, where our co-founders began their work going door to door, talking with residents about the undrinkable water coming out of their faucets, and trying to figure out how that could possibly be solved, and recognizing that it was not an isolated incident. We also have an office in Sacramento in order to bring our advocacy to the state capitol. And now we have an office in Watsonville to support disadvantaged communities achieving safe drinking water for themselves on the Central Coast as well. And just as an overview sort of to what we're up against, we're in the 5th largest economy in the world, but over 1 million Californians still lack reliable access to safe, clean, and affordable drinking water. So we're trying to turn that around via community-driven advocacy. And we do that employing grassroots level organizing, local and state regulatory advocacy legislation, and through our C4 branch political action as well. So to get into the human right to water law, on September 25th of 2012, Governor Brown signed Assembly Bill 685, making California the first state in the nation to legislatively recognize the human right to water. And that was following up a previous attempt, which actually had been vetoed in 2009 by Governor Schwarzenegger. So in 2012, we successfully added into our code, the California Water Code, that it is hereby declared to be the established policy of the state that every human being has the right to safe, clean, affordable, and accessible water adequate for human consumption, cooking, and sanitary purposes. Importantly, there's also another clause which talks about how this gets applied in the real world. So all relevant state agencies, including the department, the state board, and the State Department of Public Health, shall consider this state policy when revising, adopting, or establishing policies, regulations, and grant criteria when those policies, regulations, and criteria are pertinent to the uses of water described in this section. So sort of perfect legalese, but basically the human right to water is meant to be applied by our state agencies whenever there might be adverse effects. There are some other caveats talking about how this does not mean that the state basically has to throw all gears into action to get clean water in that instant to everyone. So, we can discuss whether that's fortunate or unfortunate, but that's just sort of where we're at. So the way that we use this law in our efforts is largely to frame and also to, as far as in our community-driven work, to really let residents know that we're not asking for something extra. They're not asking for something extra. They have a right to drinking water. They have a right to be able to use water in their homes for cooking, cleaning, to help bathe their children. This is a basic human right. And having that level of ownership over it, I think can really change the dynamic of those people who are forced to be in that position to fight for their access. So it's very helpful in that way. It's also a very clear value statement for elected officials, government agencies, and other stakeholders to unify behind and clarify what the state's goal is, what we're really looking for. So since the Human Right to Water law passed, we and our partners have witnessed and advocated for the advancement of funding, data collection, technical assistance, and other actions to better understand the problem and craft solutions to end California's drinking water crisis. Just to offer a couple of quick examples, in 2019, the legislature passed SB 200, which established a new stream of dedicated funding totaling up to $130 million annually for safe and affordable drinking water. So that is the Safe and Affordable Drinking Water Fund, also sort of renamed, funneled through the SAFER program, which is the Safe and Affordable Funding for Equity and Resilience. And so that pairs allocations from the fund and then also with regulatory actions to help struggling water systems provide safe drinking water to their customers. And we think there's a pretty clear correlation between the human right to water that was passed and that funding being established. Certainly the human right to water is part of the findings leading to the legislation and quoted in the legislation. And then we also have recently passed the Sustainable Groundwater Management Act in 2014. California really came to grips with the fact that we had to do something about our water. So in our advocacy, usually we focus on how that act deals with water levels and water quality, as that's what's affecting our residents' wells. And the human right to water really helps as a tool to push back against some very strong interests. Where we work, that's primarily agricultural interests that, though very legitimate, they have different needs for water and generally aren't as concerned about water quality. They also have normally deeper wells. So the human right to water helps to raise the voices of folks who otherwise might be more overlooked. And we apply this tool primarily at the state level, since they're the ones required to consider the human right to water. But I suppose a fair way to characterize it is that we're finding out now, as this is a new statute, the Sustainable Groundwater Management Act, we're finding out now how much that trickles down into local agency decisions. So I feel like I'm going on perhaps a bit long, so I'll just briefly mention that some lessons learned. We just have a statute. We don't have it in our Constitution. I certainly see the benefits that would come from having this codified in our Constitution. And for now, we don't have the ability to enforce this through citizen actions. And there's also a key word in this statute, which is that the regulatory agencies need to consider the human right to water. And that word is so far undefined because neither the human right to water nor this Sustainable Groundwater Management Act has been litigated yet. So there's a lot of questions around what does it mean to consider. Yeah, I think I'll leave it at that for now and welcome any other opinions from the panelists. Thanks.
And thank you, Justine. That's really helpful context for how in some ways the statutory human right to water is, in some ways, it has a mechanism that helps compels state agencies to address it. And I think one thing maybe that we can talk about later in our discussion is how the absence of what New York might do in the absence of language that directs agencies and other officials on how they should implement this human right or this environmental right. And one way in which it could be implemented is, as Katie discussed, is through litigation. And Lauren, you were one of the lawyers representing plaintiffs in Robinson Township, and which, as we've discussed, reinvigorated the Pennsylvania Constitution's Environmental Rights Amendment, and you've litigated other cases where you've framed arguments under the Environmental Rights Amendment. And what can you tell us about, based on that experience, who you think might be enforcing the New York Environmental Rights Amendment if it is approved by the voters, and who it would be likely to be enforced against?
Sure thing. And this is a good follow-up also to sort of the other panelists' discussion, because I think so far what we've seen is that there's benefits to having the statutory provision, but there's limits to how you can, and even with New York's existing provision, there's limits to it. And the benefit of having something in the Declaration of Rights has been the fact that you don't have to rely on the legislature. And when we were in the litigation with on Act 13 of 2012, which was the legislation that was challenged in Robinson Township, one of the things we were confronted with all the time was, well, the legislature gets to sort of say whatever, which is not how it works. You have a constitution, then you have a statute, that are below it. But for 40 years after the amendment had been passed or so, that was how it had been interpreted, as sort of not really meaning what you would typically mean a constitutional provision to mean. Like when you have a provision that says the people have a right to be free from, unreasonable searches and seizures, or have, a right to free speech. It's very simple language, which I think is not, I think sometimes it freaks people out a little bit in the environmental context because we're so used to everything being so prescriptive, but that's how a constitutional provision is typically written. And then it's judicially, sort of exposed, there's an exposition on it, through jurisprudence. And so, as a result of sort of the Robinson Township litigation and also the PEDF decision in 2017, which Katie, I think, touched on as well, there are more people, there is more litigation, but there's not a ton, because litigation, people forget litigation is expensive. And so, what I've been involved in is so one of the implications of the Pennsylvania's Environmental Rights Amendment, obviously it has two parts to it. It has the first sentences, which is more similar to what New York is enacting. It also has the trustee provision. There were situations in which we were dealing with local municipalities that were rolling back zoning protections, sort of like mini Act 13s, to allow more gas drilling to occur. And so we were, there were a few municipalities where we represented groups of residents who were concerned about that, and who were going to be directly affected by well sites going in zoning districts where, these gas well sites were not previously allowed. You also see it used in permit appeals. So it's interesting, the issue about, you can't sue private parties, and that's true. That's what pretty much the case with almost any constitutional provision is it requires state action. I mean, I think there's a few limited exceptions to that, but in the environmental context, you have permitting, you have a government action, you have a permit. And so I've also been involved with some permit appeals in that regard. But I would also say that the amendment, the Environmental Rights Amendment, is never my only argument, and it helps sometimes, as Justine was sort of referring to, it helps frame things, particularly issues that aren't really well discussed when you're writing a brief or you're writing an appeal. It's harder to discuss it when you've got like this regulatory framework and this permit and this permit. And I think for a lot of people, environmental law, can be frustrating from my perspective, at least, because you have people sort of looking at it like, okay, I have this permit to deal with these laws and this I got to check off these boxes. And then there's this other one, and there's this other one, but no one's looking at the whole picture. No one's looking at the impact, the cumulative impacts, unless it's somehow already specified in the statutory or regulatory framework. And I can tell you very few of our statutes and regs in Pennsylvania, require that kind of cumulative look. I think the solid waste provisions might be an exception. And those were written a lot. John Dernbach, actually, who was referenced in Katie's presentation, is one large reason for that, because he used to work at DEP for that. But in any event, this is where I start going off on tangents, but it also provides a way to try to get environmental justice in the door. Because when you say that every single person has a right to clean air, to clean water, to a healthy community, that's not something that, even if, it's, I think as Katie was referencing, the people who are talking about, oh, there's a policy decisions and balancing, and that's policy and that's the legislature, but there's also, and the regulatory agencies, but there's also the Constitution. And at the end of the day, whether there's policy choices made on, how to, there's a constitutional right to bear arms. There's policy decisions on how are we going to regulate guns. And at some point, there's, people bring lawsuits, and, the issue of, is someone's right being infringed upon or not? That's something that we're used to dealing with. And when you're looking in the environmental context and you're looking at communities that have been historically burdened with pollution, with, like, for example, Chester, Pennsylvania, was often the poster child for environmental injustice. So, if you want to put it that way, whether it be trash incinerators, a number of polluted things. And to me, this kind of constitutional language provides a way to give more argument to the fact that these things can't be ignored anymore. You can't just, step on someone's right to have, healthy air to breathe when they walk out the door because it's convenient, because it's easier to put something in one neighborhood versus another. And so my hope is, I have framed some arguments with environmental justice under the Pennsylvania Constitution. We haven't gotten very far yet, but it's still very early when you think about it, because even though our amendment was on the books for many, many years, it wasn't really, it didn't have meaning to it until now.
Thanks, Lauren. I'm interested in following up more on the environmental justice and cumulative impacts points you were making, and getting some maybe some comments from other panelists on how you view, and I know Kate, you already touched on this a little bit also, how you view the environmental rights amendment as being an avenue for protecting environmental justice communities from disproportionate and cumulative impacts. I don't know if there's anything more any of Kate or Katie or Justine would like to add on that.
Well, I sort of want to add a +1 to that comment, because I think it's really important, and it's difficult to articulate how and why that happens, but it does. That's why the environmental justice field exists to try to remedy it. And so the way that I've sort of been picturing it in my mind is just an added weight on the scale, right? And the scale is this famous or infamous cost-benefit analysis that kind of rules our world. And as we well know, often leaves out externalities and or maybe it's the same cumulative impacts. So I think that, yeah, this becomes an appropriate counterweight in policy decisions, even if it doesn't fit neatly into the math. It at least forces people to do some kind of analysis there, right? Like, how does this factor in? Am I violating this right?
And I think it also, to me, there obviously is a sort of a policy perspective on defining environmental justice communities, and sometimes that there's political decisions behind that, because I know in Pennsylvania, what got defined as an environmental justice community kind of like it kind of pushed aside a lot of historical coalfield communities because people were worried that there wasn't going to be enough money for to address all the sort of environmental and injustice issues. And I mean, we seem to have enough money for other things, but I'll just leave it at that comment there. But it's to me, it frees it up from that and to look at each community and to say, okay, maybe this isn't, designated EJ, but looking at the community, you can clearly see that there's a problem here, and that these people's rights have been continually pushed aside. And I think historically, there's been a lot of value placed on people's property rights, the ability to do what you want with your property. And by putting an environmental rights provision in the Constitution, it puts them, on par with each other. So you have to consider both of them. And of course, not everybody's property rights are, necessarily in opposition to environmental justice, because the people who own a house next to a factory have a right to, quiet use and enjoyment of their land. But crap, I just forgot the point I was going to make, but in any event, there you go.
Thank you both. And I think I just wanted to remind people, if you do have questions, you can submit them using the Q&A feature. I wanted to follow up on one other thing. I think when you were speaking, Justine, you talked about how the statutory human right to water might have been a driving force behind additional legislation that provided additional avenues for protection. And do you all think that, how would you expect the Environmental Rights Amendment in New York to change how legislators legislate and regulators regulate? Do you think it could have, it could be and have impacts on the actions that these policymakers and regulators, that the decisions that they make?
I'm happy to just jump in. I think it absolutely will, right? I mean, we're putting almost a new duty in some regard onto regulators and decision makers, legislators, to consider it just the way they wouldn't go ahead and pass a law that violated one's right to free speech. There's a screen. Now, what that screen is, what those criteria are to discharge that duty is what we'll have to figure out. And I think that's what probably creates the most anxiety amongst the for the regulators, is how do I ensure that I'm doing what I need to do to satisfy this? But I think once we start working through that, we will absolutely be providing a higher standard and duty for those decisions to happen. In the ideal world, we'll be getting to less environmental harms, creating more equity amongst New Yorkers as well. I mean, back to that question, to me, it's also the court is now being charged with balancing equities, not just cost benefit analysis of a site here versus that, actually the equities of people. and that's where you would, all things being equal, disadvantaged community, normal, wealthier community, in that calculus, the individuals that have been exposed to historic burdens are going to have their rights infringed upon more easily or quicker. I don't know if that's the right way, but that weight of their infringement of the right is going to happen in a different, will be viewed as differently as folks that haven't had those historic burdens. So I think that's an important way that the court is going to have to look at, and it really puts this equitable question for all New Yorkers, right? Not just the cost benefit of citing over one place or the next.
Thanks, Kate. We have a question from the audience, and I think, Katie, you have thought about this question. It's just the questioner says that New York's proposed constitutional environmental amendment does not have the trustee part of the Pennsylvania Environmental Rights Amendment. Will this limit the usefulness of the New York amendment?
So I'm so glad you asked this, because I realized there's something I meant to raise in my presentation and I didn't. This reminds me to get there, which is one fear that's raised about putting an environmental right in the Constitution is that the courts will somehow usurp legislative authority. And what's interesting is when I hear people express that concern, all I can think is, oh gee, they haven't read what's going on in other states, because other states that have environmental rights provisions in their Constitution, if anything, the instinct to judicial restraint is so strong that you actually have to cajole the courts to use their authority under the Constitution, to actually exercise it. And to get back to that public trust language, to my mind, the potential value of the public trust language, or one significant value of the public trust phrasing in the Pennsylvania Environmental Rights Amendment, is that it has provided an anchor that the courts have kind of grasped onto by giving them kind of a more concrete concept to apply and enforce, that they're a little comfortable with this idea that, oh, we know how duties trustees have to manage things. And it almost felt like it emboldened courts to get over their reticence and judicial restraint with respect to the Environmental Rights Amendment. So when we were on our task force, we liked that language, because our thought was we really wanted the environmental right to be to courts to interpret it in a robust way. I am encouraged, however, that despite the fact that Montana's constitution doesn't contain some similar language, courts there have interpreted and applied it, I think, in very valuable ways. So I think that you can, we will have to encourage our court in New York to overcome its instinct for judicial restraint in applying the environmental right. I do think the public trust language can be helpful in that regard, but I'm encouraged by the experience in Montana that it's not necessary.
And if I just might tag on to that, I think one of the challenges that historically people would look at the language of the first sentence in section 27 and be like, oh my God, how do we apply this? And Robinson Township laid it out very clearly, which was look to science. I mean, we can look to existing statutes and regs, but that's not necessarily the end of the story. Courts are equipped with the ability to look at evidence, to weigh experts. I mean, they do that all the time in other cases, criminal cases, whatever it may be. And so but I do think there is always a bit of reticence. And I think some of it comes down to the fact that whatever it is, the environment is seen as this political football. Maybe it didn't used to be quite as much, but it definitely is now. And I think, and we countered this in the Robinson Township litigation, where the opposition was like, well, this is just essentially a political issue. But because we have a constitutional provision, the court was like, we're being asked nothing to do what we do, which is to say what a constitutional provision means and to apply it as such, which is one benefit of having it in the Constitution. And I, at the end of the day, we can't be without clean air and clean water any more than we can't not have the ability to go, seek redress of grievances from, our government, or to be able to, speak freely. And so as much as there's some, it gets politicized, I think it's just as important, to be put in there. And it is incumbent on us as lawyers to sort of help our clients, help the courts get where it should go.
Thanks so much, Lauren. I think that is a great comment on which to close tonight's discussion. I really appreciate all of you joining us tonight to provide this valuable context about environmental rights in general and applying it to the New York proposed amendment. And I'm really looking forward to seeing what happens next week and then what happens after next week. And hopefully we can come back and have a discussion in a year about, or I don't, however long it takes, about the impacts of the Environmental Rights Amendment once it's actually, if it actually is in place. I also want to thank everyone who has attended tonight. I wanted to let you know that we will be posting a video of this event on the City Bar's website. And I think that Professor Hugh is also going to provide us with her slides so that we can post those on the website, probably on the same page where you registered, but I think that that's where you will be able to go to get to all of this information. And then thank you again to Martha, to Jonathan, everyone else at the City Bar who has made this event possible tonight. Thank you very much, and have a great evening.